My name is Brown Kairaria. I am the chairperson of the Industrial Property Tribunal. The Industrial Property Tribunal is currently based in Nairobi. We are at the South Sea, at what was formerly and still is Weights and Measures. The mandate of the Industrial Property Tribunal is to adjudicate disputes in the area of intellectual property law, and especially industrial property law disputes, specifically in the areas of patent, industrial designs, utility models, and technovations. And we deal with about 4 aspects. The first is appeals, hearing of appeals from decisions of the Managing Director, Kenya Industrial Property Institute, KIPI. So if you have, for instance, a dispute, if you have an intellectual property that, say, patents that you are seeking to register, and a dispute arises in the process of registration, and the managing director makes a decision in the process of examining your application, which you are unhappy with, then you can come to the tribunal and make an appeal, and then we will hear that appeal and make a decision, which will then guide the managing director to process your application in accordance with the law. The second set of disputes that we deal with is revocation proceedings. Say if a patent, industrial design, or utility model has been registered contrary to the requirements of the law, or you feel that it has been registered when it was not warranted, then you would have a right to challenge that registration by filing revocation or invalidation proceedings before the tribunal under Section 103(1) of the Industrial Property Act. And once the matter comes before us, we listen to it, and if you certify us that the legal criteria for registration was not properly followed, then we can issue an order to invalidate the right. Our decisions would be appealable to the High Court. The other set of proceedings that we deal with is infringement proceedings. If you have a registered right, say in the area of industrial property, industrial designs, utility model, or patents, and somebody infringes or uses or sells articles that incorporate your industrial design or your registered patent or utility model, you have a right under the law to come before the tribunal and file infringement proceedings under Section 106 of the Act. And once they come before us, then we will listen to them. Of course, there is an obligation to inform the other party. You serve the other party, and the other party would then file a response to the proceedings, and then we would hear you, and depending on whether your rights have been violated according to the facts and the law, then we would issue orders to stop the infringement. We can also issue orders to for compensation, for damages, for compensation for the infringed right. Now, the other set of cases that come before us are references, and these are usually from the Managing Director in Kenya Industrial Property Institute, and usually the references come to us when in the course of assessing an application for registration, the managing director feels that there is an issue that is a bit complex, or an issue of law that is a bit complex, or that is not clear to him, that you would require the tribunal to look at it and then give some guidance about how the particular issue should be resolved. And once we look at it, we'll then give guidelines or directions on the basis of which then the managing director can proceed and conclude the evaluation of the application. Again, as I said earlier, if a party is unhappy with the decision, then they can appeal to the High Court, and the managing director in that case would have to wait until the High Court makes a determination and gives directions. The High Court can either agree with what we have said as a tribunal, or give directions contrary to what we have said.